When I lean on it, I just got to stop. Oh, here we go. There we go. Hello, everyone. This is Curt Barone.
And Brad Pinsky.
All right. And we are here for another edition of Fire Law Roundup. It kind of caught us by surprise to start here. But this is for June 12th of 2023. Brad, go for it.
Very good. Okay, we got some really interesting ones. My favorite's going to come up, I think, is the third one, but we'll get to it. So let's start with a quick one. A little head scratcher. We have, after 13 years of litigation, we have a firefighter who was severely injured in 2006 has now settled with his employer. I don't totally understand it, other than he was burned trying severely.
It was Cindy.
Burned.
Cindy. It was a female.
Oh, female. I'm sorry. She was severely burned while trying to rescue a person. This occurred in 2006. She sued for $1 million. She finally reached the settlement agreement. And what had happened was she was injured when a floor collapsed when she was attempting to rescue an elderly man. Horrific surgeries, and it obviously ended her career. So she sued, alleging the district was negligent and failed to train them properly, leading to her injuries. She, I guess, attempted or was asked to return to work in 2013. I'm not sure, but she did not return to work back in 2013. So the district, her employer, terminated her. And so then she had a second suit alleging now wrongful termination. And she based that on the collective bargaining agreement, which said that firefighters have to stay on the payroll until they're able to return to duty, but she wasn't able to return to duty. In any event, this has been going through the court system for a while, and various degrees of success. In any event, here they have now settled it, ending everything, I presume, where she'll get $1 million. I wasn't sure. Look, settlement's not for anything specific, right? You don't attribute a dollar to a dollar, but I was kind of curious, in the employer's mind, in her mind, right? Is this more for the wrongful termination because you should have kept paying me, or is this for my injuries? Because injuries normally against an employer, all you get is workers' compensation in some form, no matter how bad they are. And here they're apparently horrific, right? But it sounds like this really addresses the wrongful termination, because pain and suffering of burns would generate way more than $1 million. So I'm not sure. It seems like this is more, okay, we agree we wrongfully terminated, or we don't agree, but we're going to pay you on the wrongful termination. And she must have had some thought, again, if that she wasn't going to be successful on the pain and suffering and all that would have come from the negligence and failure to train.
Yeah, we had a similar problem here in Rhode Island, and it was based on state law. But firefighters in Rhode Island are outside of workers' comp, so we have a separate law, and we're specifically exempted from workers' comp. So the benefit to the city is the city doesn't have to pay the comp insurance, and they don't have to deal with that bureaucracy. The downside is now the fire department or the municipality and HR has to get involved in managing the comp. And how long is somebody going to be off for? Who's going to pay the medical bills? Are those medical bills actually for the job-related injury? Are they for something that happened off the job? And, should the member come back and all that stuff? But the way the law was written is that a firefighter who is injured, the city has to pay their medical bills. So that's sort of number one with comp, the same thing. They got to pay the medical bills. But then they also have to continue their salary or their wages at 100% of what it had been at the time of the injury. So it's not 66 2/3 like it is for, but there was nothing, right? There was nothing in the state law that covered someone who was not going to be able to come off of the injury status and return to work. And so we had people that were sort of in limbo like her for years, decades, because they didn't want to retire, and they basically, it was clearly a work-related injury. So finally, the legislature had to step in and address it. So, I think what you have here, it sounds like it was in the collective bargaining agreement that they can remain on the payroll until they're able to return. But what happens when they can't? And now they're going to go for a pension. And, depending on the pension, maybe the pension isn't, maybe it's 50%, or maybe it's 66%. and the contract says she's entitled to 100%. So I don't know, a lot of different things, particularly where those surgeries go beyond the point where she should be on the pension. There's still the issue of who's going to pay for it and all that. So, I guess the bottom line is it's a good thing that it was settled, because otherwise these issues can just drag on, and the taxpayers are footing the bill. And certainly, we don't want to minimize the pain and suffering that she's been through and everything.
And she was in hard financial straits, according to this. So apparently, she might have been pushed financially into having to do this. Who knows? Well,
you're upset about, from the fire chief's perspective, you're upset about this person not just either taking a pension or whatever. And that's another thing. It wasn't clear. Maybe she wasn't eligible for a pension. Maybe they didn't have some sort of mechanism. But be that as it may, from the front office, you're a little bit upset with this person, and you're frustrated, and your budgets have, a lot of your budget now is going toward this. And so now a bill comes in, and so, you know what? That doesn't look like it's really for this injury, so we're not going to pay it. And now you get into all those kind of squabbles too, which is unfortunate. They shouldn't be happening. I'm not rationalizing it, but I've seen it where, the front office or HR or whomever declines these types of things, and then it falls on the person who's least able to pay for it, the individual.
Right.
So.
Right. Okay. Now let's head to Milwaukee, home of happy days, so to speak, and some beer. So Milwaukee has been successful. They've successfully defended suit brought by a terminated firefighter. I find this very interesting. So the firefighter was dismissed. She was terminated in 2020, January of 2020, for something that allegedly happened in 17.
Well, this is complicated now. It's a he, and he's acting lieutenant. So he must have been on the list or whatever. He's an acting lieutenant, and he gave her low grades and
a probationary subordinate. Let's get into that. So, as he's acting lieutenant, he's accused of subjecting a probationary subordinate, right, to a hostile work environment. He had previously given her a couple low grades, but then it gets kind of interesting from there. So the subordinate female accused the lieutenant of sexually assaulting her. This kind of comes out of nowhere. And that results in him getting arrested, incarcerated, and not surprisingly, placed on suicide watch. When people are, let's say, potentially wrongly accused, comes out of blue, maybe, and so now he's suicidal. I get it.
There's actually there's a question about whether or not he belonged on suicide watch, or they put him on suicide watch just so that he wouldn't be able to get out on bail. That was I was reading through it. I'm saying, boy, I wonder. And apparently the victim had some family members that were involved in.
Well, that's what we want to get to, right? So as they investigate this, so stop here. So now he's indicted. There's a criminal proceeding at the same time pending. And you and I talked about similar issues like this before. So I'll get to that in a minute. So there's a criminal issue now happening because she raised, wait a minute, he had sexually assaulted me, right? The police apparently found it credible enough to incarcerate him. So the civil matter, the discipline against him, is now put on hold. And sometimes that's a process that happens where the DA says, listen, we do not want you to interfere with anything. So the department agrees. We will put our investigation on hold, the civil investigation. Sometimes you think because if he's convicted, we don't need to investigate anything. We'll terminate him retroactively, right? But so they put everything on hold. That's kind of the key interesting part of this case. So then it comes out where this gets really interesting. Well, I presume you picked this case for discussion. Then it turns out that the investigation reveals that the female victim had a relative in the police department. She had a history of making threats like, I'm going to make one call to my family and you're going to get in trouble. But that wasn't all. they could not in any way corroborate the sexual assault. Now, I don't have details, at least in front of me, on the sexual assault, whether she claimed there would have been other people or it was in a public place or who knows. Because a lot of times he said, she said.
And that's the classic. And what, as an investigator, what you're looking for is any sort of corroboration. If you
Scarring,
have, because they're both
bruising,
right? If anything, could be video, could be someone says that they're at a certain location, and now we have cell data to put them at the location, or other witnesses who can say, yes, they were at that location, or immediately afterwards, the person did report this,
right?
Or told me.
Or take the opposite. You said it happened at 2:00, but at 2:30, you're out hanging at a bar, right? I mean, I don't know what the facts are, but so those two things, her common threat and the fact that they couldn't corroborate in any way, it gets dropped. So now the disciplinary investigation is free to continue, right? Just because there's no evidence of a crime doesn't mean that he wasn't, retaliating or took the first action against her, right? Ending in the bad.
He did. And then, he was engaging in some sort of hostile behavior toward her.
Right. So, and he was making some sexist comments. He said, you have in there racist comments too. I don't know if she's African-American or something, but
that wasn't clear, but yeah.
All right. In any event, so the issue you pick up from is the Sixth Amendment issue, right, to present witnesses, right? And so they tried to claim, I'll kind of summarize this if you want to expand, but he tried to claim, listen, because of the criminal proceeding, we couldn't present witnesses. And the court says that's not true. You weren't denied the ability to present witnesses. You were told you couldn't interview them for a while, but ultimately you were able to present them as, right, in your case, you were not denied access to them. So there's no Sixth Amendment denial. And the court really says it was a temporary hold, basically. And interestingly, the court doesn't criticize the DA or the employer for taking either tack. Don't talk to witnesses and okay, we're going to put everything on hold. I didn't take that as the court having an issue with that. But the court ultimately said, look, you did ultimately present the witnesses. So, it's a very short way of summarizing it, but
yeah, I've got so many questions on this one. And, certainly if there's anybody from Milwaukee listening that has some details, he was terminated for insubordination, basically for not doing what he was ordered to do. So my question would be, was that refusing to answer questions? When he was called in as part of the interview, did he refuse to answer questions? That could be, because he didn't sue alleging wrongful termination. That was one of the questions. He didn't sue. So it's possible he refused to answer questions, gets fired, goes to an attorney, and then the attorney says, you had to answer the questions. You can't, if you don't answer the question, you can't sue for wrongful termination. Oh, what are we going to sue for? Well, we can go after him on the Sixth Amendment.
Creative, but not available.
And they allege essentially that on the criminal case, because the firefighters were told not to talk to anyone while the criminal investigation was going on, that prevented him from preparing a defense. And the court rejected that. And you can read the reasoning of the court. They did a pretty good job outlining what the Sixth Amendment requires, but it's really limited to presenting witnesses, not necessarily interviewing them in advance of the trial, at least according to the ruling.
Yeah. And so the takeaway really is this wasn't a bad approach, right? If there's truly an ongoing active criminal investigation, let that take place. Nobody wants the interference allegations. And kind of Garrity kind of sneaks in here a little bit too, right?
It absolutely does. And it's a little bit beyond what we can get into here, but Garrity is front and center here. But once the criminal charges are dispensed with, Garrity goes away, right. And either way, the employer, even if this lieutenant or acting lieutenant was facing criminal charges, if the employer orders him to answer questions properly, does it properly, triggering Garrity, the firefighter has to answer the questions, even though the answers, potentially are immunized. And then it's up to the police now to make sure that they don't use it, they don't rely upon it, they don't have access to it, and so on. So there's a bunch of different things, and there's ways that the record can be sealed and so on and so forth. But big point here is that even if you're facing criminal charges and work-related criminal charges, because Garrity doesn't apply to things that didn't happen at work, that aren't connected to work, but where it's work-related, and this is work-related, a sexual assault that allegedly took place on duty, if you're ordered to answer questions, you have to answer the questions. And so now, and it sounds like the fire department was told by the prosecutor, just hold off on that. And the other part of this is the prosecution is not going to want you interviewing the victim in a sexual assault case. So how can you do a disciplinary investigation if you can't interview the victim? So interesting.
And look, I was getting too far off, but the burden of proof on criminal justice, right, is beyond a reasonable doubt. Right. That's the highest possible burden. That's not your burden when you terminate someone or for disciplinary proceedings. You don't have to prove beyond a reasonable doubt. So they could, if the department wanted, they could have then interviewed the female and said, okay, the police didn't believe you, but we might. Right. And could have. It's not that the police and the prosecutors felt that they could not prove beyond a reasonable doubt. That's the standard. So they say, all right, we can't prove it beyond a reasonable doubt. If the case was based on the normal civil standard, fair preponderance, they might have had a case. Yep. And certainly the city at that point is able to move forward with it. But again, he wasn't terminated for that. He was terminated for refusing an order, which I'm assuming, my assumption is, it was in order to answer questions, and he mistakenly didn't answer. So, all right, let's go to Georgia. This has got to be the highlight case. This case is fantastic because of its widespread national applicability, not as a binding matter of law, not that the decision of this appeals court is binding, but I love the holding. It's clearly going to be extremely persuasive. And so I will talk about it. But so here's the summary for your headline, that a Georgia appeals court held that EMS can rely on cancellation by police and therefore would not have a duty to the patient for which they could breach. Interestingly, however, and I'm just going to throw this out because I'm going to revisit it, the issue here, so everybody knows, to prove negligence, right? And that's not even the right way. To prove the unintentional tort of personal injury, you have to prove that a person had a duty to you. Well, that's kind of glossed over here, but I'm going to talk about it, right? Then that there's a breach of duty, that the breach of duty caused the person injury, which is a whole other thing, and that there was an injury. Here, what you're going to see me focused on is the second element, the breach of duty. And in order to prove a breach of duty, right, once you prove what your duty is, then you have to prove that we breached it. And the way you prove one of the many ways you prove a breach is there was a standard, whether that's a standard practice or there's a policy, right, or a protocol that we're required to adhere to, and we failed to adhere to it. Here, the focus is going to be a question. Is there a national, which I think is a stupid standard anyway, is there a stupid question? Is there a national standard requiring, and then I'll get into the facts, is there a national standard requiring that the EMS entity, once told they can cancel, should conduct an independent investigation to confirm the reason for their cancellation, right? In other words, police said, hey, there's no patient. Should EMS have to go back up and say, no, maybe we can find that there's a patient, right? So, and here's the facts. Basically, and I'm going to summarize them, there's a 911 call, help, somebody took drugs, whatever, I think they're in danger, and the call goes and hangs up. And again, I'm keeping these facts similar because the pertinent facts to me, right, occur after all this. The police get called, the police dispatcher gets the ambulance dispatcher on the line, which is not uncommon, but when we get to duty, that's where I'm going to say it gets very interesting. So the ambulance company's dispatcher is online with the police. The police are trying to find the house. They couldn't find the house. They finally locate the house from GPS, from I assume it's a cell phone because well, I assume it's a cell
Yeah,
phone.
they did. The guy who called didn't give an address.
They give an address. So,
Right. So
but
they triangulated.
Triangulator, or today they'd use Rapid SOS and know exactly where it is.
Yeah.
Right? So today, so anyway, so they get to the house, EMS arrives, police tells EMS, as they always do, which is the true national standard or national practice, let's not call it a standard, is police say, you stage, you wait, we'll investigate. And here they said, we're familiar with the house, we're familiar with the caller, we have some concerns, stay here at the end of the driveway. And EMS does, because you and I just held a session at our conference, which said who's in charge, police, fire, and EMS. And in this case, it's a scene safety issue to start because the police had concerns. It's a scene safety issue. So EMS stages. We're not in charge of safety. We're in charge of patient care. We don't get a patient until scene is safe. Okay. So now EMS is standing at the driveway. Police go up. For some reason, the police have a knowledge that they were told last time you were here, don't come to the front door because my father who shares a house will get all upset, which I think is crazy. So they go to the back door, they knock on the door, they wait for 5 minutes. This is all on body cam. There's no question of fact as far as I'm concerned.
They know the people's names. They know their names. They're calling their names.
Yep. They knew the whole situation. They know a lot of things about them, but the dispatcher is trying to they cannot get them on the phone. In any event, so after 5 minutes or some amount of time, they say patient unfounded or patient not found, and they send the ambulance on their way, right? Tell the ambulance you can go. No patient here to be found. We tried, we can't get in. Mm-hmm. So ultimately what happens, of course, the patient wakes up dead, right? They get another call. Right. They get another call the next day. The person who is the witness to this and the caller on the first call said, well, the woman's relationship is to him. She was cold. I thought she was cold because she needed a blanket. Then it turns out she's dead. She'd taken a whole bunch of pills last night, said she went to sleep. And she was so upset when I called 911 the day before that she hung up the phone and wouldn't let me call again, and then passes out and ultimately dies. So the question here is, but remember, the person then died at some point. So the question here is, should EMS have gone up and tried to establish a connection with the patient who the police couldn't find, right? Was there an independent duty? And what they focus on here is not duty. They focused on standard of care. So we'll skip duty for a moment, and the entire, and I think, I know somebody with the same name, but I assume it's not who it is. The expert witness they provided tried to state his opinion that there is a national standard of care, and everybody in EMS knows this is completely untrue. He tried to say there's a national standard of care by which EMS independently investigates police cancellations. And that is legal, to use a Latin phrase, pure crap.
Okay, but let's kind of narrow this, because I've been thinking about this since I wrote it. And in this situation, the police said there is no victim here. We can't find a victim, because that's really important now. Right. Okay. Change the facts a little bit. Change the facts where the police say we found the victim. They don't want transport. You can go in service. I think that's a different situation. Different
issue, because that would be, can you take a refuse? Well, and change it one more. Change it one more and say
that's my next note.
Doesn't need medical care.
That's my next one. Absolutely. Absolutely. So again, this is a lot more nuanced. This is where the police are saying, and I think that's what the expert was saying. The expert was kind of dragging in those other scenarios where the police have found someone, and then the person the victim tells the police, we don't want to go. I think there is a duty on the medic's part to evaluate that independently, because you can't refuse without it being a knowing refusal, and the person has to be competent. How can you assess somebody's competence if you haven't evaluated them? So, but again, the scenario here is where you can't find the person. And
so let's take this one, because I want to go back to something you just said. I'm not sure I'm going to agree. This will be fun. This will be a lot of fun. So like I said, this is the showcase case because it's so applicable to everybody. Yeah. So in this case, right, they said can't find the patient. That's not a competency capacity issue. It's not a do they want care, don't need care, right? And so what the court said is, listen, the expert did not establish that there was any national standard in this instance. So since there was no breach of duty, they didn't violate a standard of care. His testimony should have been excluded, and they then failed to prove that there's a breach of duty, right? I would have attacked, before we get to the other interesting part, I would have attacked this on no duty whatsoever, assuming, and I don't know, that Georgia is a special duty or, state, or however you want to use that phrase, right? Public duty rule. Because let me play this for everyone who's understands special duty. Let me rephrase it, because this is where it gets really interesting. So, and I would have kicked the case out on no duty whatsoever. So in the municipal rules, there is a protection called special duty for municipalities. Now, I don't think that private ambulance company is a municipality. So maybe that's why
that's why the police weren't named in the suit. They just went after the ambulance company.
Okay, so maybe this is why. So I'll make it a little shorter. But so the ambulance company presumably is non-municipal, except they're performing a municipal service. So they may well get the protection of the special duty rule. And the special duty rule says, listen, no person who receives police, fire, or some cases EMS protection, and there's a lot of cases that say this applies to EMS.
By government, yeah.
Okay, yep. Yeah. If you're providing that service by a government entity, then they're not liable for unintentional acts that happen to you, because they have no duty. And to form a special duty, they have to have a one-on-one discussion with you. So the victim and the person who injures you or causes you injury has to have a one-on-one relationship where the victim tells the rescuer, I need something from you. The rescuer says, I'm coming to help. And the victim relies on that rescuer to do what they said they're going to do. Think of it very simply, where somebody's standing on a balcony, say, help, I'm going to jump, I'm going to jump. The fire chief comes and says, no, we're coming for you. Stay there. We're coming. And so they rely on them, say, okay, I'm staying here. And the fire department never goes to get them. So they burn to death, right? That would be a special duty rule. The reason I think this is so interesting on special duty, and there's one nuance, which I'm not going to spend too much time on, but is the seminal issue. There has to be one-on-one contact. So not the victim isn't relying on anyone. In fact, she says she doesn't want to help because she hangs up the phone. So, right. So point one. Point two, it's a bystander, not the victim, who calls 911. 911 is the police dispatcher. And even if you said, well, and you can't hear where they're unconscious and they have implied consent, right? There's no implied anything here because the victim says, I don't want help. Maybe that's where it ends. But then the friend is on the phone to the police dispatcher. The police dispatcher is on the phone with the ambulance dispatcher, but the victim's not on the phone with the ambulance dispatcher. There's no relial. So if this was a municipal duty rule, and it could be, because this very well could be the municipal contracted ambulance service, who in many cases does get the benefit, right, when they're municipal contracted specifically, does get the benefit of the special duty rule, they would be out on duty. We would never get to the breach of the duty. But now, ending that, let's go to the great issues you raised. Let's take them one-on-one. So now they're headed, and I want to change this because you raised something really interesting. I don't know if I agree with it or not, but I'm thinking about it. All the time, ambulances are responding to motor vehicle accidents. Right. Two scenarios. Let's see how this plays out, because this has got to be great interest to everybody watching. The police call back, say there is a car accident, or there is a vehicle, but the people were just sleeping in the car. Let's take that one, because this is right. And they cancel, and it turns out, let's say it was a CO poisoning. The police just thought everyone was right. They needed medical care, but the police cut off EMS. EMS doesn't keep going en route because they said, hey, we're canceled en route. We were told not that there was a medical condition, they don't want treatment. We're told they have no medical condition, no accident at all. Would you hear say there's a breach? Would you hear say there's any standard of care or a breach of duty?
Yeah, and let's kind of get to just a straight vehicle accident. Let's not get into CO, but let's just get into a straight vehicle accident. The vehicle accident, you're looking at trauma, and so if the police are saying there's no injuries, I think that's a different scenario. Now, I can tell you here, we would go and get the refusal. We usually do.
That's always my advice to my clients.
But would it be a breach of the duty if we didn't? I don't think so, but that's not a high risk situation. This one was for an overdose. There was an initial report of an overdose. So yeah, you have that, that's in play. And I think that the nuances in the fact pattern, I think, is what makes it. And
that you couldn't find the patient, not that the patient says, I don't need care.
Exactly. Now, let's say we have a vehicle accident and the police get there and say we can't find a victim. I think I live in a rural area, okay, and we spend a lot of time checking the woods for ejections after vehicle accidents. It's what we have to do it because, now sometimes somebody gets in an accident, they call a friend and the friend picks them up and they get out of there 2:00 in the morning. We know probably impaired or whatever. But when you're called and the police say that there's nothing, I think at a vehicle accident or the people are not injured, I think that's a slightly different situation than what we have here. If you have a call of a vehicle accident, driver is impaired, and then the police are saying they don't want to go, I think it's a little bit different. And again, all these little nuanced facts.
Well, let me add another nuance. So the point you're making to the viewers, I think, is that, listen, if it's just we can't locate the patient, so there's no medical evaluation that you need to be an EMT for. Right. If you can't find a patient, we can trust you can't find the patient. So you can cancel, right? Or there was no car accident, right? It was reported as a car accident. It's a radiator issue, no car accident.
Right. That's another classic one, right?
Right. Doesn't take a medical professional to evaluate the patient or the mechanism of injury. But now what you're saying is when EMS gets, hey, the patient doesn't want care, you can cancel, or there are no injuries to this patient in the accident. Both require an evaluation of the patient, right? Capacity, competence to refuse, and whether they should be advised to go to the hospital. Do they have an injury that the person didn't see or test for, et cetera? So that one now does require, right, an evaluation. So if the police who are non-medical, I'm going to change the circumstance, if the police who are non-medical get on the phone with you and say, patient doesn't want care, you can cancel, what do? Because I have a real issue. So now change it. So look, we're all going to say, oh, of course EMS should proceed, right? Because
classroom answer.
Right, because police, unless they're an EMT, aren't competent. Okay, fine. Now the next question, are we proceeding with our lights on still? Do we turn the lights off? Mm-hmm. If we get into an accident, do we still have a good faith belief there was an emergency? So let's assume, okay, in the perfect world, we downgrade, but we keep going. Well, by that time, what if they left? What if right now, patient leaving is good for us because, say, they left. But there's all these little things that happen after okay, we're not going to trust the police to cancel us. We're going to go and get our own refusal and do our own evaluation. But here's what I'm saying. I still think there's no duty. I think for the most part, until we've reached that patient, or the patient says, okay, they're coming for me and I'm going to wait for them, there's no duty. So I don't know if there's a liability issue.
The special duty that would clearly be one thing that creates that duty. And I just put one, I think it was in Alabama. I think it was a fire department in Alabama, but it was an ambulance was dispatched. And for whatever reason, it took like 40 minutes to get there. And there was another one out of Indiana that is probably the leading case, very similar fact pattern, where it took like 40 minutes for the ambulance to get there. But the people are roughly 5 minutes away from the hospital. So they call for an ambulance and they say, we need an ambulance. Okay, we're dispatching an ambulance. Okay, that doesn't create a special duty. Okay. The people call back a second time and say, hey, it's been 10 minutes. Where's that ambulance? We're only 5 minutes away from the hospital. Oh, they should be there any second. Okay. That may create a special duty, may not. Okay. The third time, now it's 20 minutes into it. They're calling, hey, what's going on? Oh, just be patient. And the case out of Indiana, the dispatcher actually said, go outside on the front porch, listen in the distance, and you'll hear the sirens coming. And they hadn't even left the barn yet.
Wow. Okay.
Okay. So those are the types of scenarios that create the special duty, but just the phone call isn't enough to create the special duty. So again, this was a municipal situation. I think you're absolutely right. And maybe in some jurisdictions, when you're performing a public function, you have the benefit of the public duty doctrine. That may kick in here too. Okay. But my big concern with this one is just that we don't want to overstate our ability to rely on the police. Where the police have said there is no victim, patient found, you're probably on solid ground. Where there is a patient and they're saying, oh, the patient's giving us a hard time, or the patient doesn't want to transport, or something of that nature. I don't think you can stretch this holding to protect not at least evaluating the patient, especially given the overdose allegation, or the fact that there was an overdose.
Yeah. And generally I agree, right? So just to summarize in one simple line is EMS should not usually rely on police that there's no medical or trauma condition, right? It's very different than saying we can't locate.
The condition doesn't warrant treatment.
Right. Now,
they're not right.
Here, let's change. In Nassau County, New York, the police run the ambulance service.
There you go.
Right. So that raises two interesting questions.
That's a good job for them. That's a great job for them.
Yeah. So imagine for a second, now the ambulance is responding, let's say from a separate agency, but they know the police on scene is an EMT. If the person's competent to provide a medical evaluation, right? Or maybe they said, hey, doctor's on scene, says you can cancel. Would I? No, but if I'm in a busy area, well, Jesus, I know I got 5 calls pending. I was just told I can cancel. Best practice, yes, get a PCR. Second best practice, well, okay, if you're telling me I can cancel because there's there's a doctor on scene or an EMT on scene and he's performed the same evaluation I'm going to do, maybe. Right. But that's the point. And if you're from the same agency, even harder situation. But I think the expert here, at least how he was recited, misstated that there's a national standard. There is no national standard on any of this. Right. There's no rule that applies applicably nationally to anything. I don't know why we're looking at a national standard. If there was a state standard or a local standard, that would have been enough too.
The court used the term national standard, but I think, you're right. It's really it's a local or at least statewide standard as opposed to a national standard. But maybe they couldn't find a state expert that was willing to testify.
Because there isn't one. There is no state. Anyway, okay. So that's a lot about that, but that's a great issue. And it gives me another idea for our conference in April to talk about, which is maybe liability of EMS personnel. I think would be a great topic. And we could probably do. Yeah.
And when do you need to take a refusal and when not? That's one of my favorite topics. Because, people get totally paranoid, including lawyers. They get totally paranoid over, we got to get a refusal. We got to get a refusal. We got to get a refusal. And I come from a different background. I mean, obviously firefighting, but I spent almost 45 years doing ski patrol. And, the folks, those EMS folks from the fire department EMS side and also private ambulance will say, anytime there's a mechanism of injury, you've got to get a refusal. Well, as a ski patrolman, I would do nothing but get refusals because people are falling all over the place. You know what I'm saying?
Right.
But this is crazy that in order to be a patient, you've got to have a complaint. Right. If you don't have a complaint, you're basically not a patient. you got to have a complaint, because otherwise, and we have a good debate on this in some of my classes over this, because, you see somebody fall, he's going 40 miles an hour, he falls down, you're going to get a refusal from him. No, he gets up, he puts his skis on, and he keeps going.
Right. Well, same thing with a car accident. Just because you get rear-ended doesn't mean you're hurt.
Right. You got to have a complaint to be a patient. But if you want to go drive yourself crazy and be paranoid, then get a refusal from everyone who was in either of the vehicles, and the bystanders, and somebody who was a mile down the road that watched it through binoculars and everything else. So.
Yeah. Okay. Let's do wrap up with a couple of little easier ones. So we go to West Virginia here. We just have a plea of no contest, which is it's effectively a guilty plea. You're getting convicted, but you're not saying you did it. You're not what's called allocuting. So we have a father and a son. The father was the fire chief, the son of the fire chief. Apparently, the father's 53, the son's 35. And they stole money about, it looks like combined about $50,000 or so, $54,000. And so they're facing, New York, they'd be facing nothing. But they're not in New York, they're in West Virginia. So who knows, but they're facing 5 years in prison, the father, and then the son, 10 years. I don't understand that.
Sounds to me, just looking at the sentences, first of all, I would say it looks like they cooperated, because I don't think they would have gotten all of those charges reduced if they hadn't cooperated, and they were permitted to plead nolo, which on the other hand kind of makes it seem like maybe the charges weren't that they didn't have overwhelming proof. So at any rate, sometimes you never know. Sometimes it's just good lawyering on the part of the defense attorney. So, but bottom line is, it looks like they must have cooperated to some extent, and those restitution orders reflect that perhaps the son was the one who
did the
primarily did it, and the father tried to cover up for the son. I'm assuming so.
Could be
just speculation.
Yeah. In any event, father and son, they fight fires together and they steal money together. Okay.
You can pick your friends, but you can't pick your relatives, right? But I just feel if it was in fact the dad was just trying to cover up for the son, first of all, you can't cover up, if you find problems,
Okay. And let's finally end in, we're headed to the Third Circuit. We're in Pennsylvania. This is interesting, though. I say I don't understand it. I understand it. I just don't understand why the lawyers are doing this. So look, here's a situation where we've got two fire departments, one town. The fire departments were created by a town resolution, town act. And the town decides we want the two to merge. There is response issues. This other department keeps arriving too late. We want to stay with the one who's doing well. It looks like they're both volunteer departments, by the way. That's which is what's going to lead to my ultimate question of why don't we need two of them, right? But in any event, they determined that they should combine, but it's not working. Their dual response or merger is not working. And in fact, this one department was viewed as impeding the success of this entire plan. So a consulting firm had been hired. I'm not a big fan of consulting firms all the time. I see them as kind of cookie cutter, but here they said, you know what, let's have a merger. But again, the merger wasn't working. So since it didn't go well, the town then says, you know what, we're just getting rid of that other department. We're staying with the one department that's working, and we're going to change our town resolution. And now the charter or whatever, the other department's gone. They're no longer going to serve us. And so that department sued. And the test here to challenge the town's decision is whether it's a very, 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 remember before, viewers, when I said in a criminal court that beyond a reasonable doubt is a very high standard, and then it kind of drops. Well, in the civil context, there are very high standards, right? Clear and convincing evidence is a very high standard, tough to prove. Here, all the town had to show to support their decision that they didn't violate any constitution or state statute was just they had a rational basis, meaning somebody could say, yeah, that makes sense. That's really all it is.
It's very deferential. It's a very deferential standard.
It is very deferential. You're not going to beat it. When a court finds there's no rational basis, they're being delete that because YouTube. Sorry, YouTube. Giving an example. In any event, so in this case, the court just said, listen, there was a reason, right, and it was a rational reason, and so no liability. To me, I'm a little factually. I don't have enough information. I'm a little factually concerned. Billy Goldfeder always says, in order to fight a structure fire, you need 21 feet on the ground, 21 bodies on the ground, right? That to fight a single residential structure fire. Mm-hmm. So I don't know this company personally. Do they always get 21, right? Because we haven't talked about mutual aid, but it seems like if there's this other department that responds late, fine, but at least they're responding. Maybe they get there later. Now they did say, yeah, but they always try to assume command, right? Okay, well, that's fine. The town could have addressed that in another way, like cite NIMS, first arriving as incident command until it's handed over, not taken. But in any event, there's not much to this other than the court says, it was a rational basis. I'm not going to get into whether I disagree with it. I don't know all the politics, but I suppose this is one of those, and I've been in this position where occasionally you win, but most of the time you lose. A client comes to you and says, we want to stop the town from kicking us out. And you're like, but the town is in charge of you. And if they don't want protection from you, good or bad, that's what you got. And the reason I haven't taken a lot of these cases in the past, the exact reason is because the test is, do they have a rational basis? There's no way they're not going to come forward and say, oh, I have a problem. You're not financially accountable. Your training records aren't up to date. Your officers aren't trained. Your members don't show up. Your response times are too long. Pick any reason. It's their decision. In most, I can't say every state, but in most states, I presume the municipality in charge gets to determine who they want fire protection from. The fire department doesn't choose.
I think that when you think about the rational basis standard, the flip side of that is sometimes more helpful to think about, that in order to not have a rational basis, you have to have acted in an arbitrary way, which basically means you had you just kind of said, you're in, you're out, you're in, you're out, like just arbitrarily made a decision. And, to characterize this as arbitrary, like they didn't go eeny, meeny, miny, mo. It was not an arbitrary, it wasn't in bad faith. Now that's another part of substantive due process where they acted in bad faith, but apparently they couldn't really show bad faith, that they had a legitimate concern that gave them the rational basis, and there was no constitutional violation. So
yeah, the short part here is when your municipality wants to get rid of you, even if it's a bad reason, they only need a little bit of a good reason, and it's very tough to win. I got to tell you, I've had a number of cases, 2 in the last 2 years, where it's the supervisor and like, well, you didn't come to my grandmother, my mother, so I want you gone, right? There's no good reason. That's not a good reason, but they always find a reason to say you're just not serving our community as well as somebody else could, so you're gone. And here, frankly, the department had the benefit that there had been something in the town charter or town resolutions that actually vested them with some right. Unfortunately, the right was snap of the fingers, just change the resolution and, it takes it away. Most municipalities, most municipal fire departments don't have that ability. They're there by contract, not municipal departments, non-municipal departments, but they're there by contract. So I kudos to the attorney for trying to come up with something. I'm sure the attorney said, listen, I don't know how we can help you, but if you want to spend the money, we'll try to help. At least they tried something. I'm not beating up the attorney on this. That's an impossible case to win.
All right. Well, that's our 5 cases for this week. Interesting week. And if you like what you heard, please click like and share, and please subscribe. We're doing pretty good on subscribers, up to over 1,100. Still a little short on our hours, so we need about somewhere around 350 more hours of watching. So
watch this 20 times each.
There you go. If you do a little binge watching, we're going to get up there to 4,000 hours, which is going to put us in YouTube heaven. So that's going to do it for another edition of Fire Law Roundup. We'll see you